This is All India Radio. In the program Insights, now we bring you a discussion on India International Arbitration Centre. The participants are Amit Khemka, legal expert, and Rajesh Lekh, AIR correspondent.
The New Delhi International Arbitration Centre Amendment Bill 2022 was introduced in Lok Sabha on August 5, 2022. The bill amends the New Delhi International Arbitration Centre Act 2019. Mr. Khemka, why was there a need to rename the New Delhi International Arbitration Centre?
See, let us understand the purpose of creating this institution. The purpose of creating this institution is, as we all know, that our courts are choked. We know that the cases are being pending for years together. So we do need alternative dispute mechanism. And now the world is one big, country or one big city. The borders have dimmed. They have thinned, There are hardly any borders left now, especially in terms of commercial and businesses, So all these disputes have to be settled through arbitration only. And big other countries, such as even Malaysia, they are attracting huge business, huge arbitration businesses all over the world. I mean, you must have heard of International Court of Arbitration at London, in arbitration centers, international arbitration centers at Singapore, and so on and so forth. Even countries like Ukraine, they are having robust mechanism to provide for international arbitration. This requires an autonomous regime which is independent in nature and which is institutionalized and which has a professional image. Now, for that, right now, we have an institution called International Center of Alternate Dispute Resolution. Now, this institution has not been able to achieve the required attention from the international community. So it was decided in 2019 that it will be replaced with New Delhi International Arbitration Center. So probably somebody used the word New Delhi in order that because other places it is the word London or Singapore they are used. So or Kuala Lumpur is used. So this is how New Delhi was utilized. But we have one very robust system in Delhi High Court, which is called Delhi International Arbitration Center. So as not to confuse it with that, and also because to portray that this institution is not meant only for Delhi, it is meant for the entire country, or if I may say so, for the entire world. So that was the purpose for which Law Minister also said that we don't want to confuse it. We want to portray to the whole world that we want to create an institution of par excellence, institution of excellence, and that is why the tag also has been given the institution of excellence to this. So that image is created worldwide that is in consonance with the other internationally known arbitration centers. And it is the need for having such a internationally known arbitration center is that our business people are always at loss. They have to rush to other countries for having their international disputes settled. And we are of course, the business community in India is at loss. Otherwise also these centers attract huge revenues. So why not? We are a country where the infrastructure is cheaper than all other countries. So we are actually and we have very expert people who are very good arbitrators. We have a very vibrant bar. We have lawyers who are known internationally for the international arbitrations. So we are in the best position to provide these facilities and logistics here in this country. But we are not able to exploit that. We are not able to establish an institution of that kind. So it's apart, but the problem is that apart from just changing name or just giving a tag of Institute of Excellence, we will have to do a lot more. And quickly, we can't be seen as just being slow, The new act, Arbitration Act had come, Arbitration and Conciliation Act had come in 1996. since then we are, if you see the international, this kind of institution should have come at that very time. And for that purpose, ICADR was constituted, but that has not, the purpose has not been achieved. And therefore, it is necessary that we are able to portray to the whole world that we are quick, we will provide excellent services, the quality services. It is not only the name, it is also the substance which will matter.
Okay. Mr. Khemka, you mentioned that we need to do more in arbitration. Before I come to that question, let me ask you, what are the key features of the new Delhi International Arbitration Center Bill 2022?
See, right now, there are primarily two things, as I told you, that they want to portray that it is an autonomous institution where there is not much of governmental interference. They want to portray that it's an international and national institution. They want to portray that it's a center where excellence would be the priority. So these are the basic ideas which probably the government and the law minister have on their mind. But as I said, that lot more will have to be done, and very quickly. It cannot wait.
Okay. One of the key features is, as you mentioned, renaming of the New Delhi International Arbitration Center. And the other one is the alternative dispute resolution. Would you touch upon that as well?
Yes, it is alternate. We have many ways to alternative ways of dispute resolution, such as mediation, conciliation, arbitration. So arbitration is only one out of them. For example, we at Delhi High Court Mediation Center, we have an excellent track record of solving disputes where lawyers work pro bono, and we are able to sort out disputes which would have dragged for years together, especially in commercial matters, matrimonial matters, and family matters. It is of great use. So and then conciliation is something which is pre-litigation. Before the litigation, one can go for conciliation, where parties can choose their own result. Similarly, in mediation, the parties can choose their own result, and then that result takes form of an award or a decree of the court, and that is final. There are no appeals to that. So these are other ways of alternate dispute mechanism, and arbitration is one of them, where you choose your own judge. The arbitrator is in the court. You have no control on who will be the judge in your dispute. But on arbitration, you are choosing your own judge. So that is one of the basic features of arbitration.
Okay. So what you said in a nutshell is that the Act requires the Arbitration Center to strive to facilitate the conduct of international and domestic arbitration and conciliation. The other two features, Mr. Khemka, are removal of difficulties and drafting errors. Would you elaborate on that as well?
Yes, that is what I was coming to. See, what has happened is almost all international arbitration institutions have created standard forms. For example, a draft arbitration agreement is there. So otherwise what happens is, when the different lawyers or different people draft arbitration agreements in different way, then there is always a possibility of pre-arbitration litigation because of the faulty way of drafting the agreement itself. So all these institutions have a preset form of the arbitration agreement which can be utilized with whatever little changes parties want to do. But then it reduces the possibility of litigation. Then the second is the procedure, the arbitration procedure. Now, arbitration is something which is not bound by the strict principles of evidence law or strict principles of civil procedure code. But that shouldn't mean that it is not bound by any rules or laws. Therefore, it is necessary that all these institutions of excellence, or in all these institutions which want to attract people from all over the world to do arbitrations at their seat, they should be in a position to provide a standardized set of rules, how the proceedings will be conducted, how much time will it take, how much, what will be the procedure. So if those rules are arbitration friendly, if I may use the word, then people would be interested in coming to this institution, and they will be attracted to get their disputes resolved at that center. So, therefore, it is necessary that the rules, the model arbitration agreements, all these things are taken care of. Then also, there is always, whenever there is a dispute, there could always be an emergent situation where an interlocutory relief is required, or where there is quick disposal of the dispute is required, and for which arbitration is touted as one of the benefits of arbitration, that arbitration is quick. Arbitration does not drag for years together. So if you have a situation where your rules provide for emergency situations and for the interim relief or interim measures, then in that case people are bound to be attracted to such institution. Then cost effectiveness is also one of the major things. It has to be very time bound and cost effective, because arbitration, when we studied arbitration way back in 70s and 80s in our law college, we were told that arbitration is very cost effective remedy, but that has not been true. Arbitration has become so costly that it is prohibitively costly. We have started advising in some cases where the stakes are not very high, that we advise the clients not to go for arbitration because of the cost involved. So arbitration centers have to take care that the arbitrations are cost effective also. Then the expertise required, the panel of arbitrators, those arbitrators should be such, they are well-known arbitrators, they are well-known people in their field. It should not be seen only as a post-retirement facility for the judges. It should be seen as the expert people from having expert domain. They should be on the panel of these arbitration centers. That is very, very essential that these kind of things should happen. And then there has to be a robust bar. The lawyers who are available, they also, which in both cases, the expertise so far as arbitrations are concerned, because we have technical, we have commercial, we have legal, expert people of all fields of life. We have so much of talent available in this country that for very cheap rates in comparison to other countries, we can provide all this to the whole world.
So how is the arbitrator helped by this act? How are they going to be helped?
So arbitrators, of course, when the seat is in Singapore, an arbitrator stationed at Singapore is the one who is benefited. So similarly, when the seat would be in Delhi, today most of our arbitrators are enrolled at Singapore or Malaysia, Kuala Lumpur or London. So they will be in a beneficial position. But let me say one more thing here, that it is not only if you have only the arbitrators from your own country, then also it will act as a deterrent. You have to have very well-known arbitrators from all over the world as on your panel. Then only the people will have trust in you. It cannot be seen as an Indian arbitration center. So that is why probably that is what is on the mind of Law Minister as well.
Thank you, Mr. Khemka, for your views on the New Delhi International Arbitration Center Bill 2022.
Thank you so much. Thank you so much for inviting me. Thank you very much.
You were listening to a discussion on India International Arbitration Center. The participants were Amit Khemka, legal expert, and Rajesh, Lekh, AIR correspondent. This program was produced and presented by the News Services Division of All India Radio. You can listen to it on our mobile app, News on AIR. This program is also available on our YouTube channel, News on AIR Official. You may email your opinion about this program at airnsdtalks@gmail.com.